Something very strange happened in court today, and almost no one is talking about it. A last-minute rush of filings, a sudden request for more time, and a judge caught between transparency and delay. Because just as key documents were supposed to be unsealed, everything slowed down again, and what is being argued now could quietly decide what the public is allowed to see and what stays hidden. And once you understand why this moment matters, you will see this case very differently. So stay with me, because the next part explains exactly what just changed. Today felt like one of those moments where everything that has been quietly building in this case suddenly pressed up against the surface. Because what happened was not loud or explosive in the traditional sense, but instead subtle, procedural, and deeply revealing, if you know what to look for. And that is exactly why I wanted to slow this down and walk through it carefully. Because when court deadlines collide with last-minute extensions, it almost always signals stress behind the scenes. And this particular deadline mattered more than most because it involved documents tied directly to summary judgment materials, documents that help shape what the public will eventually understand about this entire dispute. And just as that moment arrived, the response was not readiness, but delay. And that alone should make anyone paying attention pause, because delays do not happen in a vacuum. They happen when something is unfinished, unresolved, or strategically complicated. And in this case, the request was not minor. It was another extension layered on top of previous ones and framed as necessary due to the volume of materials involved. And while that explanation may sound reasonable on its face, the timing raises obvious questions, especially when those materials have already been in circulation for weeks, and when other parties are expected to respond on much shorter timelines. And this imbalance is where the tension begins, because litigation is not just about what is filed, but when it is filed and who benefits from the clock slowing down. And in high-profile cases, time itself becomes a tool, sometimes as powerful as any argument. And when you track this case from the beginning, you start to see a pattern where critical moments are repeatedly met with requests for more time, more protection, more sealing, and more procedural friction. And each one individually can be explained, but together they form a picture of resistance to exposure rather than confidence in disclosure. And that matters because summary judgment is supposed to narrow issues, not expand them, and unsealing motions are supposed to clarify the record, not obscure it. And yet, here we are again with the court being asked to referee not between facts, but between access and delay. And that is not accidental. It is strategic, and it is worth understanding, because the way this phase plays out will influence everything that follows, including whether the public ever sees the full context behind certain claims and defenses. And that is why today matters more than it might initially appear. To really understand why this moment feels so familiar, you have to understand what it is like to be on the defense side of litigation, because the experience is fundamentally different from what most people imagine. And it often feels like the process assumes guilt long before any evidence is weighed. And this is not because judges are biased, but because the system is structured to allow claims to be aired before they are tested. And that structure gives plaintiffs enormous leverage early on, especially during discovery, when allegations drive access to information, and defendants are required to respond comprehensively, even when claims are later found to be unsupported. And that imbalance becomes especially pronounced when protective designations are layered on top of discovery, because those designations can limit what a defendant personally sees, even when it concerns their own case. And that creates a strange dynamic where attorneys hold information their own clients cannot review. And while that is sometimes necessary for sensitive materials, it can also become a barrier to meaningful participation when overused. And that is why challenges to those designations are so contentious, because they are not about curiosity, they are about the ability to understand and defend against what is being alleged. And when discovery drags on for years without resolution, that frustration compounds, because time passes, resources are drained, and reputations are affected regardless of outcome. And this is not hypothetical. It happens every day in civil courts across the country, and it is happening here in real time. And when you combine that reality with a court court system that is overburdened, cases can sit unresolved for months or years while motions stack up, and judges prioritize criminal matters or urgent disputes. And the result is a slow grind that benefits whoever is most comfortable with delay, and that is often the party seeking to maintain the status quo. And in this case, the status quo appears to be continued sealing, continued extensions, and continued procedural disputes, rather than movement toward resolution. And that should concern anyone who values clarity and finality, because justice delayed is not neutral, it has consequences, and those consequences fall unevenly depending on which side of the case you are on. One of the most misunderstood aspects of litigation, especially for people watching from the outside, is how depositions actually work, because they are often imagined as calm question and answer sessions, when in reality they are among the most adversarial environments in civil cases. And the reason for that is simple. There is no judge present, and the only safeguard is the transcript itself, which means attorneys are constantly balancing objection preservation with the need to keep questioning moving forward. And this tension produces conflict almost inevitably, and objections, speaking objections, disagreements about breaks, and disputes over relevance are not unusual. They are part of the process. And when you read deposition transcripts without context, they can appear dramatic or even shocking, but seasoned litigators recognize that intensity alone does not equal misconduct. What matters is whether rules are violated or whether behavior crosses into obstruction, and that line is often argued later through letters and motions submitted to the court. And what stands out in this case is how deposition disputes are being elevated into broader narratives about conduct rather than resolved quietly through standard meet and confer processes. And when that happens, it suggests that the dispute itself is serving a purpose beyond resolution. And that purpose often involves creating a record that supports later arguments about credibility or fairness. And that sometimes also involves introducing references that may never be tested at trial, but nonetheless find their way into public discussion. And that is why caution becomes critical, because depositions are tools for discovery, not stages for persuasion. And when excerpts are selectively presented, especially with heavy redactions, they can imply far more than they reveal. And judges are tasked with sorting through that noise to determine what actually matters and what doesn't. And that task becomes harder when filings blur the line between advocacy and insinuation. And this is why how deposition disputes are handled now could influence how much weight the court gives to later arguments about discovery conduct and credibility. Another layer that cannot be ignored is how easily allegations can be introduced into the public consciousness through court filings, even when they are unproven. And this is one of the most dangerous aspects of modern litigation, because the mere act of referencing something in a legal document can give it an aura of legitimacy, regardless of its evidentiary value. And once that reference exists, it can be repeated, discussed, and amplified outside the courtroom, long before any judge evaluates its relevance or accuracy. And this phenomenon is sometimes described as laundering allegations through the legal system. And while that phrase sounds dramatic, the underlying concern is real, because courts are public institutions and their records carry weight, and that weight can be misused when filings include references that are tangential, speculative, or unrelated to the actual claims at issue. And this is why judges have discretion to strike or limit such material, and why protective rules exist to prevent unnecessary harm, especially in cases involving personal history or sensitive topics. And when those protections are invoked, they should be understood as safeguards, not admissions. And yet, in the court of public opinion, that nuance is often lost, and allegations take on lives of their own. And for individuals who have experienced this dynamic, the damage can be profound and lasting, even when cases settle or claims are dismissed. And that reality makes it essential to approach current filings with skepticism and care, because not everything referenced is relevant, and not everything alleged will ever be proven. And recognizing that distinction is crucial to understanding what is actually happening versus what is being suggested. As this case moves through its current phase, the focus on unsealing becomes increasingly important, because unsealing is where the tension between privacy and public access is most visible, and courts are required to balance those interests, carefully considering not only the rights of the parties, but the public interest in understanding how judicial decisions are made. And when summary judgment materials are involved, that interest is especially strong because those materials often form the basis for dispositive rulings, and keeping them sealed can limit public oversight of the court's reasoning. And yet, there are legitimate reasons to protect certain information, including trade secrets, personal data, and the privacy of third parties. And that balance is not easy, and judges must weigh competing claims thoughtfully and without favor. And when parties request extensions in this context, it adds another layer of complexity, because delay itself can function as de facto sealing, and the longer materials remain inaccessible, the less immediate their impact becomes. And that reality is not lost on litigators, who understand that timing influences attention, and attention influences perception. And that is why the current request for more time matters, not just procedurally, but symbolically, because it signals continued resistance to disclosure at a moment when disclosure was expected. And whether the court ultimately grants or limits that request will send a message about how much patience remains for prolonged procedural maneuvering. And that message will shape the next phase of this case in ways that are difficult to overstate. What makes this stage particularly compelling is that it sits at the intersection of law, narrative, and public interest, and each of those forces pulls in a different direction. The law demands precision, evidence, and adherence to rules. Narrative thrives on implication, timing, and emphasis, and public interest seeks clarity, accountability, and transparency. And when those forces collide, the result is often messy, contentious, and emotionally charged. And that is exactly what we are seeing now, as filings become denser, disputes more frequent, and patience thinner. And yet, beneath all of that noise, the core questions remain unresolved. What evidence supports the claims? What defenses are viable? And how will the court ultimately rule? And everything happening now is either moving us closer to those answers or pushing them further away. And recognizing which is which requires careful attention to procedure, not just headlines. And that is why slowing down and examining today's developments matters, because they reveal not just what is being argued, but how the case is being managed. And management choices often speak volumes about confidence, strategy, and expectation. And as the story continues to unfold, the decisions made in this phase will echo through everything that comes next, including whether the case narrows, resolves, or escalates further. And that is why this is only the beginning of what may be the most revealing chapter yet. As the case continues to inch forward, what becomes increasingly clear is that momentum itself has become one of the most contested elements, because momentum determines narrative, and narrative determines leverage. And when neither side is willing to concede even symbolic ground, every procedural step takes on outsized importance. And this is where the broader strategy begins to emerge, because litigation at this scale is rarely just about winning in court. It is about surviving the process with credibility, resources, and optionality intact. And when you watch how each filing is framed, how objections are raised, and how extensions are justified, you begin to see who is comfortable with prolonged uncertainty and who appears eager for resolution. And that difference alone can shape outcomes, because courts are not blind to patterns, and judges notice when deadlines are routinely approached with last-minute urgency rather than steady preparation. And while any single request can be excused, repeated requests begin to test patience, and that dynamic is now squarely in play, because the court is being asked once again to accommodate a timeline that seems to expand just as critical disclosures approach. And that invites scrutiny, whether intended or not. And scrutiny in litigation is rarely neutral, because it invites questions about readiness, strategy, and risk tolerance. And those questions often influence how future requests are received. And that is why what seems like a technical scheduling matter may actually be one of the most revealing indicators of where this case is headed. Another factor that cannot be ignored is the role of expert testimony and how it functions at this stage, because experts are often presented as neutral evaluators, when in reality they are carefully selected advocates whose opinions are designed to fit specific specific legal frameworks, and summary judgment is where those opinions are tested, not through cross-examination, but through legal sufficiency and relevance. And when expert reports become entangled in sealing disputes, it raises an additional layer of concern, because expert opinions often rely on underlying data, assumptions, and methodology that the opposing side seeks to challenge. And when those challenges are delayed or obscured, the court is left to assess credibility without full transparency. And that is not an ideal position for any judge. And it is precisely why unsealing expert-related materials matters so much, because without access to the full context, it becomes difficult for the public to understand why certain opinions are accepted or rejected. And this matters not because the public should second-guess judicial decisions, but because transparency reinforces legitimacy. And legitimacy is essential in high-profile disputes where skepticism runs high, and every decision is scrutinized for perceived bias or favoritism. And the longer materials remain hidden, the easier it becomes for speculation to fill the void. And speculation rarely benefits anyone, except those who thrive on ambiguity. The procedural complexity of this case also highlights how modern litigation increasingly resembles a war of attrition rather than a search for truth, because the sheer volume of filings, motions, objections, and responses can overwhelm not only the parties, but the court itself. And when that happens, resolution slows and costs escalate. And those costs are not merely financial. They include emotional strain, reputational harm, and opportunity loss. And for individuals involved, those costs accumulate regardless of outcome. And that reality creates pressure to settle, even when parties believe they are right. And that pressure is magnified when timelines stretch indefinitely, because the uncertainty itself becomes burdensome. And when one side appears more willing to endure that burden, it can tilt negotiations and influence strategic choices. And this is why delay can function as leverage, even when no formal advantage is gained, because it shifts the cost-benefit analysis of continuing the fight. And that shift may be exactly what some parties are counting on, whether consciously or not. And recognizing that possibility helps explain why resistance to acceleration persists, even when acceleration might otherwise be expected at this stage. It is also worth examining how courts view repeated discovery disputes, because while judges understand that conflict is inherent in litigation, they also expect parties to